No discrimination on grounds of religion, race, caste, etc. Article 15. Article 15 provides for a particular application of the general principle embodied in Article 14. When a law comes within the prohibition of Article 15, it cannot be validated by recourse to Article 14 by applying the principle of reasonable classification. It is when the discrimination is based upon one of the grounds mentioned in Article 15, the reasonableness of the classification will be tested under Article 14. The guarantee under Article 15 is available to citizens only and not to every person whether citizen or non-citizen as under Article 14. The first clause of Article 15 directs the state not to discriminate against a citizen on grounds only of religion, race, caste, or place of birth or any of them. The second clause prohibits citizens as well as the states from making such discrimination with regard to access to shops, hotels, etc. and all places of public entertainment, of public resort, wells, tanks, roads, etc. The first clause of Article 15 mentions the prohibited grounds in any matter which is exclusively within the control of the state. The second clause prohibits both the state and the private individual, whosoever is in the control of the above-mentioned places. The third clause empowers the state to make special provisions for the protection of women and children. The fourth clause, which was added by the Constitution, First Amendment, Act 1951, enables the state to make special provisions for the protection of the interests of the backward classes of citizens and is, therefore, an exception to Articles 15 and 29(2) of the Constitution. Clause 5, added by Constitution, 93rd Amendment, Act 2006, provision for reservation of backward and SC and ST classes including private educational institutions. The new Clause 5 provides that nothing in Article 15 or in subclause G of Clause 1 of Article 19 shall prevent the state from making any special provision, by law, for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or the scheduled tribes insofar as such special provisions relate to admission to educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority. Educational institutions referred to in Clause 1 of Article 30. The above amendment has been enacted to nullify the effect of the three decisions of the Supreme Court, that is, T.M. Pai Foundation vs. State of Karnataka, AIR 2003, and Islamic Academy vs. State of Karnataka, AIR 2003, and P.A. Inamdar vs. State of Maharashtra, AIR 2005. In T.M. Pai Foundation and P.A. Inamdar cases, it has been held that the state cannot make reservation of seats in admissions in privately run educational institutions. There the admissions can be done on the basis of common admission test conducted by the state or these institutions and on the basis of merit. In Islamic Academy case, the court held that the state can fix quota for admissions to these educational institutions, but it cannot fix fee, and also admissions can be done on the basis of common admission test and on the basis of merit. In P.A. Inamdar, however, the court has overruled the Islamic Academy ruling to the effect that the state could fix the quota for admissions to private professional educational institutions. This amendment enables the state to make provision for reservation for the above categories of classes in admission to private educational institutions. The amendment, however, keeps the minority educational institutions out of its purview. Article 15 prohibits discrimination on the ground of religion. The evil effect of reservation is well known. The politicians who claim to the country to the 21st century, for which higher education based on merit is essential, is taking a retrogressive step in providing reservation to less meritorious students to private educational institutions. This appeasement policy of that UPA government may get some benefit in elections, but it was harmful to the nation. It would damage the Hindu-Muslim unity, which was the aim of the framer of the constitution towards making a cohesive and unified society in the country. Clause 1. By Clause 1 of Article 15, the state is prohibited to discriminate between citizens on grounds only of religion, race, caste, place of birth, or any of them. The word discrimination means to make an adverse distinction or to distinguish unfavorable from others. It law makes discrimination on any of the above grounds can be declared invalid. Thus in Nansukdas versus State of U.P. AIR 1953, a law which provided for elections on the basis of separate electorates for members of different religious communities, was held to be unconstitutional. Similarly, in State of Rajasthan versus Pratap Singh, AIR 1960, the Supreme Court invalidated a notification under the Police Act of 1861 which declared certain areas as disturbed and made the inhabitants of those areas to bear the cost of additional police stationed there, but exempted all Harjans and Muslims. The exemption was given on the basis only of caste or religion and hence was contrary to Article 15(1). The word only used in Article 15(1) indicates that discrimination cannot be made merely on the ground that one belongs to a particular caste, religion, etc. In other words, if other qualifications are equal, caste, religion, etc. should not be a ground for preference or disability. It follows from this that discrimination on grounds other than religion, race, caste, or place of birth is not prohibited. It means that discrimination based on any of these grounds and also on other grounds is not hit by Article 15(1). In D.P. Joshi versus State of Madhya Bharat, AIR 1955, it was held that a law which discriminates on the ground of residence does not violate Article 15(1). In that case, a rule of the State Medical College requiring a capitation fee from non-Madhya Bharat students for admission in the college was held valid as the ground of exemption was residence and not place of birth. Place of birth is different from residence. What Article 15(1) prohibits is discrimination based on place of birth and not that based on residence. Similarly, the requirement of a test in the regional languages for state employment does not contravene Article 15. A test in the regional languages for state employment does not contravene Article 15 as the test is made compulsory for all persons seeking employment. A law relating to evacuee property is not repugnant to Article 15(1), though actually most of the persons to whom the provisions of the law would apply are likely to be Muslims. The law did not apply to Muslims alone on the ground of religion, for if a non-Muslim falls within the definition of evacuee, then the law would equally apply to him. Clause 2, Article 15(2) is a specific application of the general prohibition contained in Article 15(1). Article 15(2) declares that no citizen shall be subjected to any of sarpanch which is reserved for scheduled caste and not scheduled caste women, because respondent was elected as Panch for Gram Panchayat only against reserved seat for scheduled caste women. The court, however, upheld her election. The court said that if the seat of sarpanch of a village is reserved for scheduled caste, then both men and women belonging to scheduled castes category can contest the election for the said post because the eligibility is only being a scheduled caste pach and not the nature of the constituency they represent as paches. She cannot be prohibited from contesting the election for the post of Sarpanch against the seat meant for scheduled category merely on the ground that she was elected as Pach from the reserved seat of scheduled castes, women. Such a position would be violation of Article 15, which prohibits discrimination of gender. Thus, the plea that a member of scheduled castes can only contest the election of the office of Sarpanch against the reserved seat for women belonging to scheduled castes, and not reserved for scheduled castes, is violative of Article 15 of the Constitution. The respondent was though elected as Pach against the reserved category of scheduled castes, women, was fully eligible to contest election for the post of Sarpanch, which was reserved for scheduled castes category being a women belonging to scheduled caste. Clause 4 Special Provision for Advancement of Backward Classes. Article 15, 4 is another exception to clauses 1 and 2 of Article 15. It was added by the Constitution, First Amendment, Act, 1951, as a result of the decision in State of Madras versus Champakam Dorairajan, AIR 1951. In that case, the Madras government had reserved seats in state medical and engineering colleges for different communities in certain proportions on the basis of religion, race and caste. The state defended the law on the ground that it was enacted with a view to promote the social justice for all sections of the people as required by Article 46 of the Directive Principles of State Policy. The Supreme Court held the law void because it classified students on the basis of caste and religion irrespective of merit. The Directive Principles of State Policy cannot override the fundamental rights. In another case, an order requisitioning land for the construction of a Harijan colony was held to be void under Article 15, 1. To modify the effect of these two decisions, Article 15 was amended by the Constitution, First Amendment, Act, 1951. Under this clause, the state is empowered to make special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. After the amendment, it would be possible for the state to put up a Harijan colony in order to advance the interest of the backward classes. The provisions made in Clause 4 of Article 15 is only an enabling provision and does not impose any obligation on the state to take any special action under it. It merely confers discretion to act if necessary by way of making special provision for backward classes. A writ cannot be issued to the state to make reservation. The principle behind Article 15, 4 is that a preferential treatment can be given validly where socially and educationally backward classes need it. Article 15, 4 is not an exception but only makes a special application of the principle of reasonable classification. The class contemplated under the clause must be both socially and educationally backward. Thus, under Clause 15, 4, two things are to be determined. 1. Who are socially and educationally backward classes? 2. What is the limit of reservation? What are backward classes is not defined in the Constitution. Article 340, however, empowers the President to appoint a commission to investigate conditions of socially and educationally backward classes. On the basis of the report of the Commission, the President may specify who are to be considered as backward classes. The decision of the government is, however, a justiciable issue. The court can consider whether the classification made by the government is arbitrary or is based on any intelligible and tangible principle. In Ram Krishna Singh vs. State of Mysore, AIR 1960, the Mysore High Court held that the determination of backward classes made in 1959 on the basis of the census report of 1941 cannot be said to be based on any intelligible principle, as considerable changes had taken place between 1941 and 1959. Backward and more backward classification is not bad. In Balaji vs. State of Mysore, AIR 1963, the Mysore government issued an order under Article 15(4), reserving seats in the medical and engineering colleges in the state as follows: backward classes 28%, more backward classes 20%, scheduled castes and tribes 18%. Thus, 68% of the seats available in the colleges were reserved and only 32% was made available to the merit pool. The validity of the order was challenged by candidates who had secured more marks than those admitted under the order. Though qualified on merit, they had failed to get admission only by reason of the government order. The court held that the sub-classification made by the order between backward classes and more backward classes was not justified under Article 15(4). Backwardness, as envisaged by Article 15(4), must be both social and educational and not either social or educational. Though caste may be a relevant factor, but it cannot be the sole test for ascertaining whether a particular class is a backward class or not. Poverty, occupation, place of habitation may all be relevant factors to be taken into consideration. Article 15(4) does not speak of castes, but only speaks classes, and caste and class are not synonymous. The impugned order, however, proceeds only on the basis of caste without regard to other relevant factors, and that is sufficient to render the order invalid. The court said that the state was not justified in including in the list of backward classes all those castes or communities whose average of student population per thousand was slightly above or very near or just below the state average. Only those which were well below the average can be regarded as backward. Thus, the main defect of the system adopted by the state was that under it 90% of the population of the state was backward. It was held that this was inconsistent with Article 15(4). Reservation of 86% of seats in technical institutions, such as engineering and medical colleges, to the exclusion of all other candidates if a single candidate from the scheduled tribes was available, would amount to fraud upon the Constitution. Clause 4 of Article 15 only enables the state to make special and not exclusive provision for the backward classes. The state would not be justified ignoring altogether advancement of the rest of the society in its zeal to promote the welfare of backward classes. National interest would suffer if qualified and competent students were excluded from admission in institutions of higher education. Speaking generally, the court said, the special provision should be less than 50%. How much less than 50% would depend upon the relevant prevailing circumstances in each case. In the historic Mandal Commission case, the Supreme Court by 6-3 majority has held that the subclassification of backward classes into more backward and backward classes for the purpose of Article 16(4) can be done. But as a result of subclassification, the reservation cannot exceed more than 50%. The distinction should be on the basis of degrees of social backwardness. In fact, such a classification would be necessary to help the more backward classes, otherwise those of the backward classes who are little more advanced than the more backward classes might take away all the seats. This interpretation is equally applicable to Article 15(4), as the words backward classes of citizen in Article 16(4) are wider and includes the SCs and STs and other socially and educationally backward classes also. On this point, the decision in Balaji's case has been disapproved, and State of Andhra Pradesh versus V. Balram and K.C. Vasant Kumar versus State of Karnataka have been followed by the court. As regards the limit of reservation, the majority has held that the total reservation shall not exceed 50%. This general rule can be relaxed in extraordinary situations for population living in far-flung areas of the country, as it may be desirable to treat them differently. On this point, the court affirmed the Balaji and Devdasan cases and overruled the State of Kerala versus N.M. Thomas and K.C. Vasant Kumar versus State of Karnataka cases. In A. Periyakrupan versus State of Tamil Nadu, AIR 1971, the Supreme Court held that classification of backward classes on basis of castes is well within the purview of Article 15(4), provided those castes are shown to be socially and educationally backward. But the court advised that the government should not proceed on the basis that once a class is considered as backward, it should continue as backward class for all the times. Such an approach, the court said, would defeat the very purpose of the reservation. The government should always keep under review the question of reservation of seats, and only the classes which are really, socially and educationally backward should be allowed to have the benefit of reservation. Reservation of seats should not be allowed to become vested interest. The government decision in this regard is open to judicial review. In State of Andhra Pradesh versus U.S.V. Balaram, AIR 1972, the Supreme Court reiterated the same view and held that caste of a person cannot be the sole test for ascertaining whether a peculiar class or community is backward class or not, yet if an entire caste is, as a fact, found to be socially and educationally backward, their inclusion in the list of backward classes by their name is not violative of Article 15(4). A caste is also a class of citizens which may, as such, be socially and educationally backward. But it does not mean that once a caste is considered backward class, it will continue to be backward for all the time. If a situation arises wherein the candidates belonging to the groups included in the list of backward classes are able to obtain more seats on the basis of their own merit, it is the duty of the government to review the question of further reservation of seats for such groups. If once a class appears to have reached a stage of progress, from which it could be safely inferred that no further protection is necessary, the state will do well to review such instances.